Thanks for attending Commandment number 9, know who and how to trust, of our 11 commandments at Forster, Boughman, and Lefkowitz. This one's, like the other ones, going to be very practical. We first started, I'm Gary Forster, and I'm here with Eric Boughman, my partner. We started doing these 11 commandments because we wanted to approach some of the more practical topics of asset protection that come up in our practice. And this one in particular is something that creates a lot of clarification for people who come into the office or use us for trust work. You know, 9 out of 10 people who call and either need an LLC or offshore work address, and Eric could say this in terms of some of the planning he's done and litigation, address whatever they're doing as a trust. So they'll say, you know, I think I need a family trust, or I think I need something with my partner to deal with a trust. And it's interesting the way people view the trust. It's likely because the trust existed since the 14th century, and people think about the trust as some place to secure assets, to create an arrangement that creates some kind of protective layer on whatever they're doing, and whether it, you know, it involves really other entities like an LLC or a family limited partnership. They really view it as a trust, even into the engagement a lot. In terms of background, the trust was. Go ahead.
I just want to hit a couple, and sorry to interrupt. I just wanted to let everybody know that we did drop the handouts, the slides that we're going to go over today, and the outline are both available on the webinar page, and so you should be able to download those. If anybody has any difficulty with the slides or the outline, if you send us a question through the webinar or let us know by email, we'll make sure that you get those.
And so they're seeing what we're seeing on, you're seeing what I'm seeing, but you can also download the material.
They'll have the outline.
From that constant contact.
Right. And so just so everybody knows how we operate, you have the slides that we'll go over on the screen, and then we also have a written outline that provides much more detail about what we're going to talk about. And so we'll stay generally within the outline, but we may go off into some areas of interest, particularly if we have questions, which of course we welcome. But I just want everybody to know that they have all of the material there. And then I know Gary wants to go into some of the background. I just wanted to just give everybody an overview of what we're talking about today for those who didn't really prepare for or get anything in advance or look at anything here in advance. And so we popped the agenda up on the screen. And basically today's seminar is about, as Gary said, it's trust. We're going to talk about the different types of trust, particularly ones that folks are interested in are the asset protection trusts, domestic and offshore. And we'll talk about creditor attacks on trusts and how creditors, people trying to crack the trust, try to get into them, and what the different mechanisms are to do that. And that allows us to then look at the creation of a trust. And when you're doing the formation, when Gary's in the planning phase, for instance, we know what to look out for and what people are going to try and do to unwind the trust, so we can try to avoid that from the front side. And throughout, we'll do a Q&A at the end, but throughout, if you have any questions, please let us know. And with that, I'll let Gary go into some of the background on trusts.
So, thanks, Eric. I always skip around, so Eric keeps me honest here, just so we get everything organized. We want to make sure you have everything you need. Well, in terms of background, you know, in the 15th century, when an Englishman would go off to war, basically an arrangement was developed whereby he would appoint someone who wasn't initially called trustee, but that name developed over a couple hundred years, to hold money for his wife and children, or just his children. And this developed into a situation where the trustee could not benefit by this money, and the beneficiary child typically could not have access to the money. So we called this a divided title. And it's very interesting because the rest of the law doesn't really correspond with divided title. So if someone's bring suit, which is, you know, what drives most of our case law. We have these appellate decisions that drive our case law and did so for hundreds of years before even this country existed. They sue someone. So let's say they sue the grantor who started the trust. The grantor doesn't own the asset. They try to sue the trustee, but the trustee's not really the defendant in the claim, or the trustee, beyond that, cannot reach the assets for his benefit. He doesn't have the right. It's like a contractual right to those assets. And then so the beneficiary gets into trouble, and this was what created the trust fund baby, is the trust fund baby has no legal right to reach the assets. So this is what creates asset protection with trusts. I know some of you online are familiar with this, but we typically like to go through some of the background to ensure that everyone understands why trusts are, you know, how they developed and why they're so protective. And even after a state like Florida adopts the English common law as its first set of laws at the end of the 19th century, that was true here too. So this tradition developed over a period of time. You can see, if we go to the next slide, what some of the details are in terms of trusts. So you talk about self-settled trust and well, okay, here we go. Distinctions, I see. So I'm on the right page here. So you have the spendthrift distinction, which basically says that, you know, you're a beneficiary child. You can't reach these assets pursuant to the terms of the trust, and you know you can't really assign your interest. You can't say, you know what, I want to get some cash out of this. I want to assign, or I want to take a mortgage on my interest in the trust. This prevents you from doing that. The spendthrift provisions kind of eliminate that issue. It's not really much of an issue anymore. It's been so many hundreds of years. It's pretty clear that if someone can only get distributions when the trustee decides that they don't have any right to assets. In number B here, you have revocable versus irrevocable trust. Some of the requirements associated with the protections, whereby if someone sues a beneficiary or someone sues a grantor, they can't get the assets. Some of the requirements associated with that are basically that the grantor has to completely divest themselves of any right to recover those assets. They're in the trust, and the beneficiary can't reach them either. Special purpose we have here, there's a number of names that have been developed over the years for these irrevocable trusts. But for instance, you know, a special purpose would be, you know, a trust arises to care for the needs of someone who cannot care for themselves. So that would be a very classic reason, not an asset protection reason per se, of creating a trust for like a disabled child with a trustee you trust who would make distributions as the child needs. Now we have, there's also spins on this, like the special needs trust, which is something where the trustee will not make a distribution to the child if in fact that distribution would cause the child to lose, you know, like state-sponsored benefits. So there's all kinds of spins on this, but what it comes down to is that the beneficiary can't reach the assets unless the trustee says so, and the beneficiary can't assign the assets. So anyone, if the beneficiary gets into some kind of litigation or owes money, there's just no way to get the assets. So what's developed though in the 1980s was this idea of asset protection through trusts was very attractive to wealthy people, but they wanted to have some access to the money. So in the 80s, you had several, typically former English colonies offshore say, you know what, we're going to abandon the idea that a self-settled trust is not protective. Self-settled means you fund it yourself and you're a beneficiary. So a lot of money went offshore to these trusts because although, you know, there's all kinds of academic speculation on the fact of whether or not they're really protective, or if in fact a U.S. court gets a hold of these foreign trusts, what's it going to do? we know now that bankruptcy courts will typically ignore the trust, and especially under the wrong situation. We're going to get into some of the details of those cases, within the next 20-25 minutes. But a lot of money went offshore. So what had happened then over in the late 90s, early 2000s was first Alaska, then several jurisdictions in the U.S. now offer a trust. You could fund yourself, and under the statute, if you use a trustee in that jurisdiction, in Alaska, in Nevada, whatever, it's technically protected. So let's get into some of the details. What's the next
Gary, just
topic?
to clarify, can you talk about the using irrevocable trusts or some special purpose trust like a land trust or something of that nature for asset protection, and explain to the folks why that's not good?
Yeah, so every week, Eric and I come across a revocable trust, which it depends on the state you're dealing with, but it's a trust you settle for yourself that says what's going to happen when you die. I call it a fancy will. Some people don't like that. It really is like a fancy will. It's called a revocable trust. You can change it whenever you want.
I've seen them called living wills or living trusts, or not
living
trusts.
Living trusts. Yeah, living will is pull the plug document. But the living trust, same thing. Yeah, some states actually use that term exclusively, living trust. It doesn't create any protection. It's a fancy will. It gets confusing because now you have a situation with the offshore jurisdictions, one of which I've become very familiar with over the years, in Nevis, West Indies, and then you have 16 states say, you can create a trust that you're a beneficiary of. Now, it's not a revocable trust per se. Most of the jurisdictions make that clear. It is you have to disgorge yourself of the asset to a third-party trustee. It is a completed transfer, unlike a revocable trust, which you can basically terminate whenever you want. Many of the states do, in some ways allow a backdoor termination of those trusts, which kind of make them revocable. The law on that's starting to play out now. And we'll get into why, why you may want to do a domestic asset protection trust that you fund for yourself, and why you may not want to do it. Does that get into some of the basics? I think so.
We'll talk about that. And right now, at last count, we have 16 states that allow domestic asset protection trusts. Florida is not one of them. And we'll talk about when you have an asset protection trust that's created in one state and you're in another state, or the assets or beneficiaries in another state, that creates some problems. So that's what we're going to talk about here in the next few slides. And the first state, by the way, to have an domestic asset protection trust was Alaska. So understand first that these are still relatively new products, asset protection trusts that are domestic or onshore asset protection trusts. And so some of the issues that come up are courts are facing those for the first time. So let's talk about one of the main first cases that dealt with a challenge to the enforceability or the protection of an asset protection trust, and this is In re Huber. And the citation for this case in more detail is contained in the outline. And if anybody's interested and you want a copy of this case, I can provide it to you as well. It makes great reading for late at night.
Very interesting.
Yeah. What happened in Huber was that a debtor filed. It was a state of Washington resident. And he had a significant amount of assets that he put into self-settled trusts for his own benefit. He used Alaska because Washington does not have a self-settled trust statute. So he used the Alaska statute and he created Alaska trusts. But the problem is he did have an Alaska trustee, but he was a beneficiary. All of the assets were in Washington. He had no real connection to Alaska. His business was in Washington, and he ended up filing for bankruptcy protection after being chased.
Well, I don't think he started with an Alaska trustee. I can't remember exactly how it worked. There was a question on that.
Yeah, there was one
And he went
Alaska
bankrupt.
trustee, and the Alaska trustee rolled over when the
And he
Alaska
went-
trustee
oh,
was
that
challenged
was-
by the bankruptcy trustee. But he did end up in bankruptcy, and basically what the court looked at there is the court said, well, you've got all of your assets in Washington. You're a beneficiary. You know, he could have maybe split it out and brought in some other beneficiaries, but he was the beneficiary. He was in Washington. Oh, he had a co-trustee who was his son, who was also in Washington, and he had no real connection, no bona fide connection to Alaska. And ultimately, the court, and this was a 2009 case, so it's not that old,
No.
the Washington bankruptcy judge decided to apply Washington law and said Washington's got a strong public policy against self-settled trusts, and you don't have any connection to Alaska, so we're going to use Washington law, regardless of where the trust was created, and allow the bankruptcy trustee to pierce the trusts and get to the assets, just as if that trust, or excuse me, those assets belong to the debtor himself.
So where did he go wrong here? First, he didn't study the history of what happens in these cases. So there's a long history now at this point, from the early 90s, whereby the bankruptcy court completely eliminates any protections associated with self-settled trusts. So you had a number of cases, starting with what was called the Portnoy case, where someone would fund the trust offshore, usually in a fraudulent transfer or some kind of controversial way, and then would end up somehow in bankruptcy court. And there's this little sleight of hand that the bankruptcy court does where they say, well, you're in, Portnoy, for instance, was in Connecticut. You're in Connecticut. Connecticut doesn't allow self-settled trust. The defendant says, well, you know, I did the trust. It's a real trust. It's in the Cook Islands, or his was in like Isle of Wight or something. And it's all set up. We're all done. We followed the rules. I've got a foreign trustee, and you know, what more could I have done? Court says we don't care. We don't care. You're here, and we're going to use public policy to say that because you're here, the law applicable to that trust is the law of Connecticut, and Connecticut doesn't allow self-settled trust, so there is no trust. Now, in some of those cases, the assets were offshore, so there was no way to, you know, reach the asset. Some of those cases, they were onshore, they'd lose the asset. But in other cases, what they would do is an offsetting. So if there was any asset available to the bankruptcy court, which might otherwise be protected, for instance, in bankruptcy, because there are exemptions in bankruptcy in terms of what you can keep and what you can't keep if you file bankruptcy. They would eliminate your ability to keep those assets because the trust assets were $1 million. We can't get them, so we're going to go ahead and take these other assets. So this happened 5 or 6 times, and we kind of learned our lesson. I can tell you at this firm, we basically never counsel bankruptcy. It would be a very special situation to counsel someone to go bankrupt, because we know that you're going to go down this road where the court is eventually going to ignore this trust. It's not going to do you any good, or they're going to do the offset. A perfect example, I don't know if you wanted me to handle this on Mortensen, but it's a perfect example. It's a great example, because the guy was a little bit of a kook. That's in this Two Little I, Mortensen. He was a little bit of a kooky guy, and he was getting a divorce, and he ends up doing this fraudulent transfer, which means he's running away from his wife, and he's in Alaska, and he puts it into he's in Alaska. He puts it into an Alaska trust. So he's there, the trustee's there, the assets are there. So those are your 3 factors. He's complying except for the fraudulent transfer. So what happens? Wife's attorney may not have been that slick and kind of lets the statute of limitations on fraudulent transfer pass. So then once that's passed,
and that's the state statute.
That's the state statute. Hasn't filed bankruptcy. state statute passes, she cannot claim fraudulent transfer and reach into that trust. So now she would have to void the trust. She'd have to have the trust disregarded, and she was going to have a hard time because he's there, the assets are there, the trustee's there, and a court in Alaska is going to say, well, that's our statute. I'm going to uphold it. We really kind of wish that would have happened in some ways. But what does he do? He files bankruptcy. So he changes all the rules, and bankruptcy carries a 10-year statute of limitation on fraudulent transfer, especially for, it's kind of vague, the language, but for asset protection purposes.
Yeah, they specifically, it's a good example of where the bankruptcy courts, when they did the 2005, the new Bankruptcy Act, they actually put a provision in the Act addressing self-settled trusts under Section 523 and providing for a 10-year look back. It's just, there's a perfect, next month we're going to do a seminar on, a webinar on bankruptcy with asset protection, but it's really a perfect example of where, if the bankruptcy judges don't do it, then when they're actually writing a law, it really, they consider some of these techniques repugnant and will write specifically draft language to make it difficult. But,
yeah, I mean, I talked to one of the guys who was involved in the legislation in 2005, actually, and the Senate voted on this because someone got up and said, why would we allow anyone to do a fraudulent transfer for asset protection purposes, just like that? And of course, there was no explanation, so it went through like that. So now he goes bankrupt. He opens up a 10-year statute, which is really what it was for. I mean, when I say why I question is because there's abuses of it, this 10-year statute. But in this case, Mortensen completely gives back all the assets to the wife, goes bankrupt, and now he's exposed. It was crazy, and loses the assets.
He creates a trust, which would have worked, but for the fact that he filed for bankruptcy protection.
Right. It's amazing.
But now we have here in the next line that sometimes the self-settled trust actually works, and Trustco v. Matthews is an example of that. This involved actually a Florida resident using a Delaware asset protection trust. She was actually one of the beneficiaries, and she also had other beneficiaries to the trust. So there were several beneficiaries, and she established 3 trusts in Delaware with a Delaware trustee for her and her children, and ended up defaulting on a commercial mortgage loan that ended up with Trustco suing her for deficiency. And there, she had the trusts, but the Delaware court focused. Now, she did not file for bankruptcy, so the Delaware court there focused again on the state statute of limitations. There was a question on what law to apply, whether to apply Delaware or Florida, but there's not much difference. But it was under state law, and
yeah, the law issue. But the question is, why did they sue?
Well, that's one of my weird questions. Is why did they ended up? It ended up holding up. The trust did. So the trust stood up because they could not unwind the trust. They tried to unwind it through a claim as a fraudulent transfer, and it had been more than 4 years since the assets were transferred. But what they never tried, Gary and I both talked about this, and so I think what Gary was alluding to, was that why didn't they just bring a suit, for instance, in Florida, and seek to invalidate the self-settled trust? I mean, if she was a Florida resident, which she was, they could have sued her in Florida, and they could have just sought to ignore the trust, similar to the Huber case.
Just like Huber.
And say, Florida has a public policy against, and that's what, by the way, we say that the statutes, the law of the land, represent the public policy of what we want our law to be. We choose our legislatures, and they write the laws. So we don't have a self-settled trust statute, so it's pretty easy to make an argument that Florida has a public policy against self-settled trusts. Otherwise, we'd have a statute that allows them. And we should ignore that trust and treat the trustee as a straw man, similar to Huber, and just treat those assets as her own assets.
So it's another example of the likely of counsel not studying the history of these trusts, because honestly, at this point, if you form one of these trusts and you're not living in the state where the trust was formed, like for instance, you're from Florida and you formed the trust in Nevada, there's some chance if someone can get the suit filed in Florida with Florida jurisdiction and Florida law, that they're going to invalidate that trust. And they didn't really pursue that here.
Yeah, I would have loved to have had a shot at that, representing the creditor, but I didn't get it, because I would have certainly brought that suit down here. And in the last case, and we've talked about this some other webinars, it's really sort of it's an outlier, but it's certainly a warning, and it's not that old. It's this Kilker v. Stillman case. It comes out of California, and there was a California resident who created some assets, some self-settled asset protection trusts in Nevada, and Nevada is another state that allows domestic asset protection trusts. And he was he had, by the way, he created these trusts in the early 2000s, and he was sued several years later, well after the statute of limitations would have passed, for some site work for installing swimming pools and building houses. And so some of the homeowners sued him, and when he was sued, he entered into a settlement, agreed to pay him, and then subsequently did not pay him, which I think the court probably didn't like that. Courts like to see cases get settled and get off their docket, and this guy doesn't pay. And he, the folks representing the plaintiffs there sued him for breach under the settlement agreement and tried to go collect from him on a judgment. And there was a hearing, and he said, well, I don't have any assets in my own name more than $500. I have I engaged in asset protection by having these Nevada trusts created, and so I don't own anything. So sorry, too bad, so sad, but nothing to give you. And the court didn't. And
he kind of said that.
Yeah.
He was a little cocky.
And the way I'm conveying it is the way I imagine in my, I imagine that's not how the hearing went.
There was a suggestion that he was cocky.
Yeah, the judge took some of, when he wrote his opinion, the judge took some of the quotes of what this of what Stillman said during the hearing, and he didn't like it. And I will tell you, when you read it, it's not a long opinion. It's kind of interesting. The court sort of jumps through a couple hoops, and here's one. Compare this with Trusco v. Matthews. We're past the 4-year statute of limitations, so the claim is dead. Here in Kilker, and this is around the same time, 2012 case. This was Kilker gets sued, and I think the suit started around 2009, and he had done these trusts back around 2001 or 2. It was like 8 years.
Yeah, this was not a controversial matter, but he likely made it into one.
And here's what the court says. It's kind of scary. Is the court there says, well, one of the issues that we show if you're trying to prove a fraudulent transfer is that the debtor moved assets with intent to avoid a creditor. And that's why we always say that the best time to do asset protection is when the skies are clear, when you don't have anybody chasing, you don't have any creditors beating down your door, preferably when you just don't have any debt. But that's rare, and we have ways to work around that. But you want to do it when times are good. It's like insurance. So you can't get in a car accident and then go call your insurance agent up and ask for coverage. So we counsel people to do these things when times are good, and by all appearances, that's what Mr. Stillman did. This claim hadn't arisen. He didn't have anybody coming after him. He just decided to set up these asset protection trusts, and it was several years later when this happened, and I think what happened there with the judge is that he didn't like what Stillman did, so he said, well, you engaged in asset protection, and that shows at the time that you were trying to avoid creditors. And it doesn't matter that it wasn't these folks. It could be anybody. And that's a fraudulent transfer. I'm going to unwind it and let them get to your property.
Even though it was 8 or 9 years before, which probably even foreclosed a fraudulent transfer claim. So that's what happened here.
Yeah, so we give you sort of the gamut there of like some of, we learned from Huber and these other cases, what to do and what not to do. And basically, with domestic asset protection trusts, you really got to focus on, what are the things that are going to unwind this if you have a problem, because that's why you need it. So let's touch a little bit on where it's, I'm sure Gary will say, and I would agree, that much safer, and and that's on offshore self-settled trusts, or offshore asset protection trusts. And Gary, you want to give some background there?
Yeah, these were actually first. We don't put them first in the outline to give you some domestic background first. The three of the principal jurisdictions here are at 3A, Nevis, Cook Islands, and Belize. The Nevis Trust statute was recently updated. It's quite good. Cook Islands is quite good too. I think Belize is fine too. The key to these statutes is the assets are offshore. They're in trust. The trustee has to be offshore. You know, to create these, I see these sometimes where a foreign trust is created where the trustee's onshore, the assets are here. I think there's going to be a lot of disadvantages to that. I think you're going to get back into this Portnoy line of cases where a lot of this stuff's going to be disregarded in litigation. You know, to give you, you know, we didn't really go through litigation, the scenarios in this seminar, but you know, when someone goes through a long litigation and the judge is worn out and everybody's worn out, the judge really then at that point expects that the plaintiff, if the plaintiff's successful, to pretty much get paid. So you're always fighting that uphill battle. To fight it domestically, we think, is a lot harder than to fight it offshore if your trustee is offshore and your assets are offshore. The protections are there. In these jurisdictions, the protections are there. We've done quite a few offshore trusts. Actually, it's picked up substantially for whatever reason. I think the political environment or something. And the key, and Eric would tell you this as a litigator, that, you know, if the assets aren't here and the trustee's not here, it's just going to be, there's a threshold on the collection amount at that point. If you're not trying to collect $1 million at that point, it's just going to be, it's going to cost so much money to deal with this. That's beyond the law. It's just a huge factor. And then, of course, these jurisdictions, like several now states, offer protectors. So when you set up these trusts, typically it's someone who wants to take a portion. Some practitioners say, you know, put all offshore. We typically like diversity of asset protection. So we'd say a portion of these assets would be offshore, and then you would, of course, take tremendous precaution. You'd use an established trust company, and then you'd have a protector on the trust. The protector would operate solely to have a veto right on any distribution. So if for some reason, we've actually never had this in our practice, a trustee goes off the ranch, or there's some theft or something that, you know, you don't really experience with these larger trust companies. There's no withdrawals or distribution that can be done without trustee approval. We like a trustee and a protector offshore. We've found that, you know, U.S. people don't have a protector offshore, so sometimes the protector would be U.S. and would have a sign-off power on any withdrawals from any of the accounts associated with the trust. The advantages are just that here in 3B. The advantages are, you know, you've got this line of cases with respect to foreign trusts and domestic trusts where a different jurisdiction or a court in a different jurisdiction is dealing with those trusts. And if they're just pretty much disregarded. If your jurisdiction, you get sued in Texas, Texas doesn't allow for self-settled asset protection trusts, and they say, well, we're gonna pretend, because that's what's really going on, in my opinion. We're gonna pretend that your Nevis trust is a Texas trust, and therefore it was self-settled, so it doesn't protect you. That's going to happen now. We're moving in that direction completely. So the advantage is it's in another country. You know, most Americans don't want to put all their assets in another country. So, you know, a block of assets, we deal with very wealthy people. You know, a block of assets in this bombshell type fortress offshore with a foreign trustee and a protector is really unbelievably protective. We're going to go through a couple of the, you know, classic cases.
Yeah, and I'll add that when I've actually been in court dealing with a plaintiff trying to sue a trustee, a non-Florida-based trustee here in Florida, and we were hired just to represent the trustee and argue against jurisdiction, and we were successful with that. If you don't have a trust, if you don't have assets here and the trustee really controls the assets and that trustee's somewhere else, you try to sue the trustee here. If the trustee doesn't have any connection with Florida, they're not going to come here, and the court's not going to be able to drag them here. And even if a court went off the ranch a little bit and purported to exercise jurisdiction over a trustee that was never here, if the trustee's in another state or another country and all of the assets are under the control of the trustee and also in that jurisdiction, even if you get a judgment here, you still got to carry it to the other jurisdiction. So if you do one in Nevis, you still got to go to Nevis to go either get a judgment against the trustee to enforce it and domesticate that judgment there against the trustee and compel the trustee to act, or something similar.
Very difficult. Very difficult.
The FTC.
Yeah, I think it's going to be difficult. We've dealt with the Nevada even domestically. If the law involves, if it's a Florida law issue, we want this case actually to see what happens. But if you're in Florida and you have a Nevada Domestic Asset Protection Trust, and the trustee and assets are in Nevada, you basically have to win your case, and then you have to take your judgment to Nevada. And we want to see, the statute in Nevada suggests that you can't do that.
Yeah.
So we want to see if you can do that, because that's called the full faith and credit provision of the U.S. Constitution. That issue is entirely eliminated with an offshore trust. To give you some deeper background.
And let me just we'll pop on to the next one, go do a couple examples. But if you get into this, if you're a planner or you're looking at potentially doing a domestic trust, a domestic self-settled trust, and you look somewhere like Nevada, Nevada has several companies, trust companies, that are only in Nevada, and just be careful that you don't do something like I don't want to pick on anybody, but a big bank, Bank of United States that has a branch everywhere, and say, okay, well, they're going to be my trustee in Nevada. And all I got to do if I'm representing somebody here is just go down to the local branch down the street, serve them with a subpoena or a summons, and I'm going to drag them here. So be careful. There's several companies, even some, I believe, we do some work with some groups where it's a national company, but they create a separate entity in Nevada, and you want to make sure you do that.
And a few of the big banks have a separate entity, too.
So it's just one of those things to look out for. Just because the office is located somewhere else, you want to make sure they don't have any connection whatsoever to, if, for instance, if we're in Florida, so we want to make sure they have no connection to Florida. And then we'll talk about another case. And, oh, by the way, if the trustee ever comes here for anything, you don't want anybody that ever comes to Florida either. I actually had somebody that had no connection, a foreigner, a Canadian, had no connection to Florida, and we were in the process of, had filed a motion for jurisdiction, and we had it set for hearing, and in the meantime, unbeknownst to anybody, he shows up here for a conference and gets sued or gets served when he hops off the plane. Bang, jurisdiction. We had to drop our motion. All right, so let's talk about this Rush University case and what happened here. This was a guy up in Illinois. You want me to give the background on that, Gary?
Well, you can give the back. It's this old line of cases starting with Portnoy, and then now we have this Rush University. You're great with this.
Yeah, So Rush University, actually the guy gave a bunch of money, or pledged a bunch of money to Rush University Medical Center, and it was to get his name on a building, and something ended up happening. While he was alive. Yeah, while he was alive, he did that.
So he died.
And he was supposed to leave a bunch. He was supposed to leave them a large portion of his estate for an endowment, and actually the backstory of this is kind of interesting. He got sick. He had some type of terminal illness, is what I recall.
And they treated him.
And he blamed them, basically. Who knows? Maybe it was a cop-out, so he didn't have to give him any money. But he sort of blamed them, and so he reneged on his deal and passed away. But he had created, there were trusts that he created for himself and for other family members. But the self-settled trusts that went back to his estate, the problem there is that that's right, he had the foreign trust, he had the Cook Islands one. And the problem is the assets that he held in. He held a lot of real estate. And so he put the real estate in this foreign trust.
U.S. real estate.
And U.S.-based real estate, a lot in Illinois. And of course, what's the Illinois court do? Very similar to Huber. Illinois court says, well, Illinois doesn't recognize these same trust laws as the Cook Islands. And we're going to go ahead and pierce the trust and go right for the assets that are in the trust. So we just use this case as an example of, especially if you are in a situation where you're reneging on something of that significance monetarily.
And this doctrine of ignoring the trust is alive. This is not even bankruptcy court. This is just, it's alive.
Yeah, this is just an Illinois court that just basically treated the trust as though it didn't exist and went ahead and went after his real estate and other property that he had in Illinois. So, you know, that's and what we say here is that, you know, any weaknesses in the trust are going to show up when they get challenged. I mean, that's really what the moral of the story is if you have any tie to a jurisdiction that doesn't recognize whatever particular trust that you're using, if you have bad actors, you know, whether you're using, you know, your beneficiaries are, you know, husband and wife doing reciprocal trusts, or if you're in a position, you know, some of these folks have, you know, there's cases where people rip off a bunch of consumers and the FTC goes after them. Anytime you put yourself in a situation where this is going to be challenged, any weaknesses, somebody's going to figure it out. So how do they do it?
The judge is on the side of the plaintiff. It's going to happen.
So here's a couple ways. These are the things that we look out for and how somebody's going to try and crack through your trust. First one is excess control. You have to have separation between legal and equitable interests in the trust. So, you know, at a most fundamental level, you can't set up your own trust. You can't be both the trustee and the beneficiary. And better that you don't set up your own trust.
You can fund it technically, but you can't control it.
Then you can't be in control. You can't be the beneficiary or can't be the trustee. And control, we've seen the cases tell us that control can be a few ways. Revocable trusts fall into this. You know, even though you make somebody else the trustee, you have a right to tell the trustee what to do. We'll see a case a little bit later. We cited one in our outline, the Bilzerian case. In that case, the beneficiaries who created the trusts and the settlers of the trust actually had provisions in the trust that made the trustees answer to those same folks who established the trust. So the trustee wasn't really independent. It was considered a sham. And obviously, you don't want to be a beneficiary. Better that you don't even have a close relative, somebody that they can put pressure on that's a beneficiary, or at least have a second one. And then alter ego. Alter ego is where the individual and the trust are essentially considered one and the same. So you may say that was one of the things that was looked at in the Huber case. One of the things the court looked at was, you know, an alter ego argument. Those assets, there's no difference between the trust owning those assets and you enjoying them and you just enjoying them.
It's a similar claim.
The trust is alter ego to you.
So we just had a case, interesting enough. There's an estate planning strategy that whereby a relative sets up a trust with a marginal amount of money, and that trust is for the client, right? So someone else sets up the trust with a marginal amount of money, and then the client comes in who's the beneficiary, and the beneficiary puts money into their own trust. I'm not sure. I understand the tax side of it. It's a means of eliminating assets from the taxable estate. It's a strategy to kind of segregate assets out. It's usually the client is the beneficiary and the client's children are beneficiaries. Besides the tax, though, hundreds of these trusts were set up in the mid-2000s, where the one we just had, we were asked to serve as expert witness, but we actually passed on it. It wasn't. We've done two. I was in one with Eric. I'm letting Eric know. It wasn't that one. It was a separate one where the client's mother set up a trust for the client with $10,000. So people like Eric are like, well, that's pretty much the greatest thing you could ever say to me if I'm trying to break the trust. So then the client put in whatever, $4 million. And you know, in Boca firm, other firm, they kind of took their estate planning position, their estate tax avoidance position. But the problem is that now you've got this highly suspect structure for asset protection purposes. So we fast forward 4 or 5 years, the client has a huge creditor, and we're asked to serve as the expert witness that the trust, in and of its terms, will protect the assets held by the trust from the creditor. Of course, there's two sides. The other side has a witness, expert witness, that says it's just a joke. So we try to explain to the client that this is a joke and we're not going to do it. But by the way, the client did actually find someone to serve as expert witness to say that. And the ruling was disastrous. It went as far as the judge could possibly go to eliminate any possible protection associated with the trust, even to ignore trust law in general. The judge was actually unwound the whole situation to make those assets available to the creditor. So we have to be very careful when we start to tinker with some of these very significant factors of not controlling the trust, not being an alter ego, not being able to tell a trustee what to do, not being able to dissolve the trust, forming the trust, in a very economically real way, for it to work for asset protection purposes. You may get away with an estate tax plan that could work, especially if you file a certain way, because the IRS only has a certain amount of time, something like a fraudulent transfer, to question the structure. But for asset protection purposes, it should be very clear. And here are your factors.
Yeah, so we only have a few minutes, and we'd like to take any questions anybody has. Let's see, somebody asked, about a Florida case that we talked about where the judge would unwound the trust. The citations for any cases that we referenced, other than the one that Gary just talked about, that I think he's probably got some confidentiality issues on, I'll tell you, all the other citations are in the written outline that you should be able to pull off of the GoToWebinar page. If you can't, I'll go ahead and I'll follow up afterwards and send you an email with all the case citations and answer any questions that anybody has. So factors for alter ego, we list them in there. I don't want to go through them because I want to be able to kind of get to the next point. Another mechanism, sham trust, and the classic one is that Bilzerian. This was husband and wife set up. Husband sets up the trust for the wife, wife for the husband, husband's the wife's trustee, and vice versa. We saw a lot of that back when tax law was considering changing the gift limitations a few years ago, and you really had to avoid the reciprocal trust. Well, same thing in the context of asset protection. These reciprocal trusts, especially with excess control by reciprocal trustees, very likely to be held just to be simply a sham. And especially, again, Bilzerian was sued for some pretty bad stuff. And then finally, we've had other webinars. We could talk about this for almost a full hour on its own. These the repatriation orders, where basically we call this the brute force method, and this is where the creditor, and usually it's a very well-funded, powerful creditor like a government agency or a big investment bank, as in the Lawrence case. A creditor goes to the court and says, we've got this judgment, so-and-so owes us $7 million, and they put all their money in an offshore trust. It was a fraudulent transfer, they're hiding the money, and we want the court to order them to bring it back. And then you get the question of, well, sometimes the court does order the folks to take action, whether it's repatriate those assets, or in the FTC, the Affordable Media case there, the FTC wanted to be appointed trustee. And in both of those cases, they're up there, FTC v. Affordable Media, that's referred to as the Anderson case. And in the Lawrence case, Lawrence spent 7 years in jail. The Anderson spent time in jail.
The bankruptcy court's going to be very much more onerous.
Yeah, and Lawrence was pretty, from what I understand of my reading, he was pretty obnoxious too. He was moving the money around offshore. I understand the takeaway there is that the government will put on and Lawrence wasn't sued by government. He was sued by Bear Stearns. It was option calls back when the last market crash. These repatriation orders, if you don't comply, you can end up going to jail for contempt. So who says there's no longer debtor's prison? And but we have cases where what the debtor says is impossible. US v. Grant's an example. Our line grant was the beneficiary of a trust set up by her husband. They owed the IRS, I don't know, $62, $63 million, but who's counting? And the IRS said, we want you to repatriate that money. And Arline Grant said, I can't. I've asked the trustee. I send him a message. I say, dear Mr. Trustee in the Cook Islands or wherever he was, please send the money back. And the trustee says no. And that actually works sometimes.
Now, that she didn't set up that trust.
Right, her husband set it up.
Which was a pretty nice factor, and it worked out. It worked out for her.
And so, but as we note there in sub 5, the impossibility can't be self-created. That's what they tried to say in Bilzerian again. And he said, well, I don't have any ability. The trustee controls it. It was like his wife or something. And the judge said, and the judge really didn't like the Bilzerians. He says, if you have restrictions on the trust that are keeping you from being able to repatriate those funds, that's a problem of your own making. Let me know if you want to talk about it one of the times over lunch or between meals while you're in jail. And then there's there are legitimate reasons that you may set up a trust even while you have creditors. So BB&T v. Hamilton Greens, that doesn't fit exactly into the impossibility category, but we want you to know that just because you have creditors, we don't have time to go into that case. We talked about that one before, but he had some pretty good reasons that he gave the court even while he was being sued. And he was sued on a fraudulent transfer, and it was a $3.4 million judgment, deficiency judgment. And the judge found that he didn't commit a fraudulent transfer. He had legitimate reasons for setting up an offshore trust, and it held up.
Yeah.
So if you have any questions, let's see. I've got some questions on credit. I'll answer those offline. The CE credit for the CPAs, I'll go ahead. We'll send that out to you. CLE credit from the Florida Bar, we're checking. We submitted this about 2 months ago. Ironically, I've got the CLE credit numbers for our seminar for next month on Commandment 10, and I've got an acknowledgement that they're working on our one for Commandment 11, which we're doing in January, but I don't have this one.
Let's make sure, send in your email if you want the CLE.
Yeah, if you need CLE credit and you don't get it, just
we can't really control the bar a lot of times.
But we'll get it done for you.
We will get it done. We'll get it out to you. Apologize for that. It's just that it's kind of hit and miss with the bar sometimes.
And so I apologize, we don't have the number to give you today. Keys to the effectiveness of these of trusts, understand, that these aspects that are important, where are the people, where's the trustee, the beneficiaries, the assets, avoid the excess control, the things we talked about during the past hour. And let's see. CE for enrolled agents. I don't think we have that, but I'll check into it and see if we can set that up.
I think it's the same as the CPAs, but we could check that.
All right. And if there's any questions, I just want to also thank you all for attending today. I want to do a few just quick announcements. We have some events coming up. Of course, we have a happy hour that we're hosting this evening at Mesa 21. I understand several of you are joining us. If you would like to join and have an RSVP, please let us know by contacting our office or Gary or I by email. Next Thursday, on November 2nd, Gary and I are doing 2 hours of presentation. We were asked to do an extra hour this year after the last couple of years doing one for the Orange County Bar Association. Our 2 hours, we're going to spend one on an asset protection update of significant cases and developments over the past year in 2017. And then the other hour, we're going to do something a little bit new. We're going to do a seminar on foreign trusts and cryptocurrencies. Cryptocurrencies are things like Bitcoin, Ether, and the digital currencies that are so hot right now. And we're going to talk about why digital currencies actually make a pretty good asset to hold in a foreign trust and how you would go about doing that. Yeah, moral of the story, someone puts a note here, don't use legal shield to set up a trust. Not if you're using it for asset protection. That's a good point, thank you. Let's see, we do another webinar. We will do our asset protection. The 11 Commandments series will continue in November, but Thanksgiving is on our 4th Thursday, so we'll push it to the following Thursday and do it on 11:30. And that one is titled Don't File Bankruptcy. Or avoid bankruptcy, and we'll explain the reasons why. It's some colorful cases, so some folks may get a kick out of that. And then finally, For next year, we're considering, we'll have another, we finish up with an ethics. The 11th commandment deals with ethics, so don't invite others to the party, and that'll be in January probably. We'll do a wrap-up maybe the month after, but for next year, 2018, we are still kicking around ideas for our monthly webinars, and we welcome your feedback. So if there's something that somebody'd like us to talk more on, an asset protection, or even if it's a little bit different, maybe something like data protection, privacy, anything dealing with your personal assets, intellectual assets, tax, corporate, any of the things that we do, we'll and consider doing a webinar. Or if you'd like us to speak at an event, either at an event that you're involved in, or come into your office. If you have a few folks that'd like to do a little roundtable discussion, we can try and even get it approved for continuing ed credit, and we'd be happy to do that and host it at our place or at yours. And with that, we are at 12:58. We got 2 extra minutes, and we've been asked if the webinar is available. We are recording the webinar, and we'll send out a link for the recording afterwards, and we should have all of those posted. I gotta say this, we started off, so I got an extra minute and a half here. If you started listening to us in the beginning, we sounded like we were a complete mess. We had some technical errors within the last 10 minutes. One, I couldn't log on to our system. I was trying to do a new log on, and we have a 2-factor authentication. My phone is down, and I've got this black screen, so I couldn't get in the computer, so I'm emailing our tech guy to try and figure out how I can log in, so I couldn't log in for you folks to get going. Then we finally got it started.
You did it.
We didn't get the CLE. Then Gary comes in, he says, well, I'll take over, and he starts, and then somehow he knocks a glass of water over my desk. It's been like this, the first 10 minutes was like a comedy of errors.
We're all going to be at the happy hour. It's at the Mexican place that was Gargie's on Lake Ivanhoe, and we'll see you there. Try to RSVP if you can. It's going to be open bar. I guess I don't know if we're going to do some kind of ticketed thing. And
meet us at Gargie's, the old Gargie's, Mesa 21. We'll look forward to seeing everybody out there. Thanks again for joining us, and have a great rest of your day. Bye-bye. And by the way, yeah, we record this one, and we have recorded our past webinars as well, and there should be links to those on our website. If you have difficulties, shoot me an email. We'll make sure we get you those copies. Thank you, everybody. Have a great day. Bye-bye.